LRE, over the years, has been one of the most litigated areas in general education, or in education. Very litigated. Lots of hearings, due process hearings, state-level hearings, OSEP rulings, and court cases. Now, these standards that these courts use can be kind of useful, because what you do by looking at these court decisions is you get an idea of what hearing officers, judges, how they approach the whole question of what is the least restrictive environment for any particular child. There have been a lot of cases heard by the U.S. Courts of Appeal for the various circuits. They're also called circuit courts or appellate courts. They're very important, very influential. When they say something that covers millions of people and has strong policy influence. But you've got to be in it's most important in the jurisdiction where you are. So this is just an example of the circuit court boundaries. We're in the 7th Circuit in Indiana. That circuit covers Tennessee, Kentucky, Ohio, and Michigan. Now, you probably can't see, there's little division signs in each state. Like in Indiana, you have a division right here. That means you have 2 district courts in your state. And if a district court hears something in Indiana, that's pretty important for you because it applies to you. But if it gets appealed to the 7th Circuit, that's important in not only Indiana, but also Illinois and Wisconsin. So, but all these circuit courts have heard cases. They're very important because school districts in Texas, you better pay attention to this. School districts in Indiana, you better pay attention to this. This is law in your circuit. A court is going to, because courts follow precedents, they're going to look and follow those decisions. Now, I'm going to tell you about what I believe to be the most important circuit court case heard yet on LRE. It was a case called Daniel R.R. v. Board of Education. Case involved a young boy with Down syndrome who was being educated. He was in kindergarten, wasn't actually in kindergarten, but his parents met with the school district. They wanted to be educated in a Daniel to be educated in a pre-kindergarten class it was generally a class for non-disabled youngsters. So they said, fine, we'll try that. We'll put Daniel R.R. was put in that. After about a half a year, they said, the teacher came and said, boy, it's just not working. This is not appropriate for Daniel. He is not learning anything. I have to spend an inordinate amount of my day with him because he has problems. He's just not learning. It's not right. It's not appropriate for Daniel. So the school met and they decided to move Daniel to a special class placement. That second level on that continuum. And what happened is parents disagreed, filed for a due process hearing, went to due process. The party that lost at that level appealed to the next higher level, the district court, finally wound up in the U.S. Court of Appeals for the 5th Circuit. And the 5th Circuit said, well, okay, what we have to do here is we're going to establish a test to use to determine if the school has adhered to the LRE requirement of the idea. And what they said is we're going to have a 2-part test. It's actually taken right from the law when you think about it. It said, can education in the regular classroom with supplementary aids and services be achieved satisfactorily? If education in the regular classroom can't be, then they go to the second part of the test. If the answer was no, and the school intends to remove the student from the regular classroom, has the student been mainstreamed to the maximum extent appropriate? In other words, have they taken steps to integrate the student with disabilities with non-disabled students to the maximum extent that they could? Well, it looked at the case and they said, well, there's clear evidence here that Daniel was not learning. He was not mastering any skills. Furthermore, he was taking so much of the teacher's time that her attention was divided, so she wasn't able to give an education that she felt was appropriate for the non-disabled kids in the classroom. So they said, well, no, education in the regular classroom could not be achieved satisfactorily. It was not appropriate for Daniel. Then they went to the second part. If no, and the school intends to remove the student from the regular classroom, which they did, has the student been mainstreamed to the maximum extent appropriate? Well, the school had Daniel ate lunch with students. He was in recess for students. I believe he might have been in art class. So there was some attempt to mainstream him into the classes where the IEP team felt that was appropriate. And so therefore, Daniel the Daniel court decided in favor of the school district that they had followed or adhered to the principle of least restrictive environment. But this is really interesting. Excuse me. They went on to say that the major principle of the law is called free appropriate public education. That means an education that's provided at public expense, free, provided in conformity with the student's IEP, and confers meaningful educational benefit. And they said, well, FAPE can be kind of at cross purposes with LRE sometimes. Sometimes, to deliver a FAPE, you're going to have to move a child out of a regular classroom because that regular classroom is not appropriate. And so in this case, that's what they did. Now they said, on the other hand, the school has to make some good faith efforts to make certain that Daniel was educated in the general education classroom. And they said, did the school take steps to accommodate Daniel in the regular classroom? And they had. They had done a number of things. Were these efforts sufficient? Or were they mere token efforts? And they said, no, they had made some real good faith efforts, and they documented these efforts to maintain Daniel in the general classroom. But it wasn't working. And that's the fourth thing. Will the student receive educational benefit from regular education? They said no. And what effect will the student with disabilities have in the regular classroom environment? Well, Daniel wasn't a problem, but he was taking so much of the teacher's time, they felt he did have a negative effect in the general ed classroom. So the court found in favor of the school district. But I also wanted to talk a little about a case called Beth B v. Van Clay, which is your own Seventh Circuit case. Beth B was actually a child with Rett syndrome, very, very severely involved. Had no communication, very little muscular control, was very seriously disabled. The parents wanted her educated in the general classroom, and the school did educate Beth in the regular classroom and determined she was not really learning. They tried to modify, and the court reported one where the kids were studying about meteorology. Beth would be given pictures of clouds and things like that. So they did try to modify, but it wasn't successful. What the school district decided to do is move Beth up that continuum to a special class. Well, it's actually a special class not in her home school, but in another school for severely disabled youngsters. Actually, there were different grade levels, but that was their program. And they had really made pretty good faith efforts to try and educate Beth, but it just wasn't being successful. The parents were unable to reach any compromise with the school district, so eventually filed for a due process hearing. In the due process hearing, well, long story short, what happened is they lost in the hearing and in the district court, and so they appealed to the U.S. Court of Appeals for the Seventh Circuit, and they took the case, and essentially what they did is they found for the school district. And they said a couple, I think, interesting things. One is that the FAPE requirement is absolute. That's absolutely the most important requirement, that we deliver a free, appropriate public education to youngsters with disabilities that confers meaningful educational benefit. And then they said FAPE and LRE are two sides of the same coin, but LRE is relative. The most important is what's appropriate for the child. They said LRE requirement shows clearly Congress strongly preferred that kids be educated in the mainstream, but they said, and this is a quote, it does not require or even suggest doing so when the regular classroom setting provides an unsatisfactory education. And they believe that Beth was not receiving an appropriate education. Therefore, that was the FAPE setting for her, was the special class, which trumped LRE. They said, they used a term, which I'm sure you're probably familiar with, called reverse mainstreaming, but they used it in a different way than a lot of people use it. What they meant by reverse mainstreaming is you've got to provide opportunities in which the child with disabilities, even though they're in a special setting, special classroom, can interact with non-disabled students. So you have to provide some amount of integrated settings. And what they said is, so long as it includes reverse mainstreaming opportunities, as well as time spent with non-disabled peers in non-academic classes during special projects, lunch, and the like, it is an acceptable point along the continuum of services between total integration and complete segregation that satisfies the requirement that Beth be mainstream to the maximum extent appropriate. In essence, what they were kind of saying is, it's not just LRE, it's not just least restrictive environment, it's least restrictive appropriate environment. In all these cases, they actually tried the regular classroom and provided supplementary aids and services to try and keep the child in general ed, and they just determined it was not appropriate. So, good faith attempts at inclusion. That's important. Now, as I said, none of those cases I've showed you has ever said a school district absolutely has to try the general ed setting first, and only if they fail do they move them up. No court has ever said that. But in reality, it's probably not a bad idea to try to try and educate the child in the regular classroom setting with supplementary aids and services. And if that is not successful, then move the child. But make those good faith efforts at inclusion. Second thing, involve the parents. That is one of the most important things you need to do. Understand, and it's a fatal flaw when you do not involve parents. Excellent documentation. All these school districts kept track of all the supplementary aids and services that they had attempted, the results. They had data. They did a very good job at documenting. They're trying a lot of different things, documenting those things, and if they failed, they documented that. Integrate when appropriate. That is, Daniel was in lunch and recess with non-disabled peers. Beth B was in lunch and recess, and I think an art class. So all of these students were included when it was appropriate. Now, it wasn't appropriate in the general ed classroom for math or reading or social studies, but it was for some, so when it was, they were included.